14, my lord.
Item number?
14, 1-4. The matter has
Yes.
become infructuous, my lord.
Why it has become infructuous?
This is regarding AGM of 2016, my lord. Normal 2022, my lord.
Exim.
AGM, my lord. Annual General Meeting of Assam Cooperative. My lord.
Mr. N.J. Khatuniya, learned counsel appearing to the writ petitioner submits that the subject matter of the writ petition being the validity of an AGM of a cooperative society held in the year 2016, the matter has become infructuous. First up, taking note of the submission of Mr. Khatuniya, his writ petition stands disposed of as infructuous.
I am appearing for 1, 2, and 3.
Then Mr. S.K. Talukdar, learned.
My lord, similar prayer for item number 16 also, my lord.
All right, learned standing counsel cooperation department is present on behalf of respond numbers
1, 2, 3.
1, 2, and 3. Similar prayer for?
In respect of item number 16, my lord, I got the relief, my lord. Got the relief, my lord.
Acha, you write in item 16, Mr. N.J. Khatuniya, learned counsel for the petitioner submit that the grievance of his client has already been redressed and therefore nothing survives for decision in this writ petition. In view of the prayer made by in view of the submission made by the petitioner's counsel, this writ petition stands disposed of as infructuous.
Obliged, lordship.
May it please your lordship, with the consent of the other side, my lord, I beg to mention item number 25, my lord. Then Mr. D. Sahu is appearing, my lord. His leg has got fractured, my lord. 2 weeks.
Item number?
25, my lord.
Item number 25.
25, my lord. I'm making the prayer on behalf of Mr. D. Sahu, my lord. He is the newly engaged counsel here, my lord. His right leg has got fractured, my lord. He is
This is the company petition.
my lord.
I'm for the respond number 1, 2, and 3, Lord.
What do you have to say?
No objection, Lord.
Mr. Sahu is for the applicant.
My petitioner, my lord.
Prayer for adjournment has been made in this case on the ground that the briefing counsel, Mr. D. Sahu, has suffered an accident leading to fracture of his leg and therefore he is not in a position to appear before the court today. Full stop. The prayer is not opposed by Mr.
A. Deka.
A. Deka.
K. Lordship.
K. Deka, learned counsel, appearing on behalf of the respond numbers. Respond numbers
1, 2, and 3, Lord.
1, 2, and 3.
And she is appearing.
Your name, please.
M. Borua.
Similar is the stand of Ms. M. Borua, learned counsel, representing the respond number 4. In view of the above, hearing of this matter stands adjourned for how much?
2 weeks, my lord.
2 weeks. Yes.
Oblige your lordship.
May I please, your lordship? Lordship, I beg to mention item number 13 of the daily list. Lordship may not like to take up this matter.
Item number 13.
Yes, lordship.
Yes, what do you want?
You may not like
Achha.
to take up this.
Let this matter be listed before any other bench without me. Bracket my name. Yes.
Deeply obliged.
May please, your lordship, my lord, I beg to mention item number 28, my lord. My lord, in this item, my lord, the management is in the process for engagement of new counsel, your senior counsel, your lordship. I have taken the consent from the opposite side, your lordship. May kindly be fixed on 12th of December, your lordship.
Is this matter tied up with this bench?
My lord.
Is it a tied up matter?
No, my lord, it will bench 4 matter.
We will
Oh.
bench format. Oh, yes.
All right. Ms. B. Chaudhary, learned counsel, is present on behalf of the writ petitioner. Mr. N. Anik Singh has appeared on behalf of the respondent IRCTC and submits that a new senior counsel is being engaged so as to argue the matter on behalf of his client, and therefore this matter be adjourned for 4 weeks.
It may be listed on 12th of December, your lordship.
Adjourned till 12/2022. Full stop. It has also been pointed out that this matter pertains to civil bench 4. Full stop. In view of the above, registry to list this matter again on 12/12/2022.
Not 12, my
Before the
lord. Senior counsel, Mr. P.K. Goswami is appearing for the petitioner. He'll be here.
both of you agree on a
No,
date,
14,
please?
14.
14
14.
December.
As agreed to by learned counsel for both sides, registry to list this matter again on before the appropriate bench on 14/12 2020.
Obliged,
Order passed earlier.
Interim order passed earlier to continue.
obliged.
Much obliged.
Lordship, I beg to mention item number 21 of the daily list.
14 go over 12 now. Yes,
21 of the daily list, Lordship.
21 of the daily list. Yes.
Lordship, matter may be adjourned only for the day.
Why? This review petition is coming again and again and again.
Lordship, senior has some issues.
You wait, we'll see when the matter is called up. You'll be there.
May it please your lordship, I beg to mention hearing item 32. As the senior counsel, Mr. S. Datta is out of station. He has taken consent from the respondent.
Item?
counsel. 32.
You are praying on whose behalf?
Petitioner said Mr. S. Datta. Senior
Petitioner's counsel.
counsel, my lord. It may be fixed after 2 weeks, my lord.
All right. A prayer for adjournment of the hearing of this matter has been made on behalf of the writ petitioner on the ground that the arguing counsel is not available. None has appeared for the respondent. Full stop. Be that as it may, on the request of the petitioner's counsel, this matter stands adjourned. Hearing of this matter stands adjourned for 2 weeks. This writ petition shall not be treated as part heard before this court henceforth. Yes.
Must oblige.
Order is vacating item 1.
Anybody will henceforth, this matter shall not be treated as part heard before this. Yes, what is this?
My lord, in this case, originally, my lord, your lordship
Sound
may
to
be
go
pleased
ahead.
to see the order dated 27/4/22.
What is this IA for, Mr. Kalita?
Yes, my lord, yes, I am stating, my lord. On 27/4/22, my lord, a
What is this
conditional,
IA for? I'm just asking that.
yes, my
question.
lord, they connected with this order, my lord.
This IA is for what?
I for, my lord, for granting, for vacating the stay order, my lord.
Say that. Which
Earlier, my
order?
lord, there was a-
Vacating which order?
That is 27/4/22, my lord.
Where is the order? Page number?
In the order sheet, my lord.
Oh, Mr. Kalita. Can't take it up. The order which is sought to be vacated is not even a part of the petition.
Actually, that was not annexed. my
We'll
lord.
hear it then in usual course. This is
Let's-
not the way it is done. Mr.
Only 1 minute, my lord.
Hmm.
In that case, my lord, on 27/4/22, my lord, a conditional order was passed
Hmm.
to deposit 5 lakhs by the petitioner. And that is to deposit before the corporation, my lord. Then what happened, my lord, the matter was listed before Honorable Justice Medhi, my lord. Honorable Justice Medhi declined, my lord, because he will not take this case. Thereafter, my matter did not come before any bench, my lord.
Hmm.
In the meantime, it was SEC dated 12/4, my lord, that 3 months expired.
Hmm.
Then the matter came before this court, my lord, on 31/8, my lord. 31/8, my lord, when I placed the matter that there is, this SEC is already expired, that is the period of the SEC is over.
Hmm.
So either they may be directed to deposit a fresh check or stay order may kindly be vacated. Then this honorable court, my lord, verbally intimated me that you file an application. That's why we have filed this application, my lord. And
No, there is
now,
no difficulty with that. What we are asking is, when an order is sought to be modified, you are asking the court to go through the record, see the order, and then come back to this IA. Is that what the stand is?
we have not annexed that, my lord. Only, my lord, your lordship may be pleased to see, against that application, my lord, they have filed an objection
Hmm.
in the miss case, my lord.
Objection, is it on, it's not on record, it seems.
They stated, my lord, that they are ready to pay another check.
Is the objection there? Objection is dated?
Objection dated, my lord, we have filed on 26/9/22.
It's not there.
At page 18, my lord, their affidavit.
The affidavit is not there. Where is the question of page 18?
May I make one
The
submission?
affidavit is not there. The order is not there. So only thing you can decide is next date. Is it there?
At page 18 of their affidavit, my lord.
This is affidavit in reply filed by the writ petitioner.
Yes, my lord. Against
Against the-
my application, my lord.
Affidavit in opposition filed by respondent numbers 1, 2, and 3. Is this the one? Please show.
May I make one?
Your
small-
objection in the IA or in the?
Both. I have
Huh?
given both.
Both, my lord. In I also they have given.
What I pray before your lordship, subject to your lordship's convenience, my lord, antemetam may come up for final disposal. Because of the
No, no,
reason,
Mr. Borgia, that is another matter. They have come before the court with a request to vacate the stay order.
they have misled the court, my lord.
That is another matter. That we can say after the matter is heard.
Yes.
But this court will not hear the matter today because the order is not there on the IA. I will not hear the matter. Please bring the order on the IA. When do you want it? Day after tomorrow?
Actually, my lord, in writ petition order is there. That's why I have not filed, my lord. There are 11.
No, but is it not required to annex the order which is sought to be vacated? Is there no such requirement? You call the registered. How he has registered this, I want to know. Mr. Kalita, please wait for some time. We'll take up your matter.
Yes, my lord. Actually, they
Call
have
him. Call the registered.
admitted that they are ready to pay another check, my lord. That's why I am pointing out, my lord. Let them issue the check, my lord. It is. If miscase. Miscase can be disposed of, that's why, my lord.
No, we will take action against the register for registering this case without the order. This is not accepted. It's not acceptable. Can you wait for a little while? 10 minutes? Can you wait for a little while? Mr. Kalita, this court has taken a consistent stand in these matters that when the order is to be vacated, it should be a part of the application. That is the requirement of the rules. That is the filing rules. It cannot be registered without that.
My lord, I was under the impression that the order is already in the record, my lord. That's why we have not annexed.
Not take up the matter. Let the register come. If there is no such requirement, then we'll take up.
Yes.
If there is a requirement to annex the order, then it has to be rectified.
Then
Sorry.
I
to
will
say.
wait, my lord. Or
Wait for 10 minutes. Yes.
again.
May I please, your lordship? My lord, I pray for further 2 weeks time to file additional affidavit in this case.
What is this IA for?
That was filed for implement of the new incumbent, my lord. By mistake, my lord, the notice was served prior to filing of this application. Therefore, court granted us liberty to file an additional affidavit by serving a copy of the notice of the conduct petition.
On the request of Mr. S.K. Chakraborty, learned counsel for the applicant, 2 weeks further time is granted as last chance for filing the additional affidavit as directed by this court. As earlier directed by this court. This is the matter accordingly.
Item 3.
May I please, your lordship? The IA for impeachment as a reference number 13 to 22, my lord.
Is it audible? I am not being able to hear anything now. Is it audible? Can you all hear everything? Clearly, Kuni said. Huh? Huh? Both of you have different versions. This side is okay, that side is always a problem. At least the sound is not coming here. Huh? See, he's also saying it's not coming. Yes,
IA for increases respondent number 13 to 22, my lord.
IA filed by?
I filed by shareholder of the cooperative settlement.
Yes, for what? What is this IA for?
I for implement, my lord.
What is the ground? Why you want to be implemented?
We are the shareholder and candidate of this election proceeding, my lord. The writ petitioner, they have filed this writ petition praying for allowing them to participate in the election process. They are the disqualified member, my lord. They are not holding the AGM in due time. Thereafter, their candidature was rejected. Then they approached before this honorable court.
Who is for the writ petitioner?
Petitioner, my lord, name showing R. Borua.
Whose name?
Name showing.
Have you served copy on him?
Yes, Lord. Yes, sir.
All right, we'll give him one more chance next week. Heard Mr. A.K. Azad, learned counsel for the applicant. Also heard Mr. S.K. Talukdar, learned standing counsel, Cooperation Department, Assam, appearing for the official respondents. None has appeared for the writ petitioner. None has appeared for the writ petitioners, although the name of the counsel is duly reflected in the cause list. This IA has been filed with a prayer to implicate the applicants in the connected writ petition on the grounds stated in the IA, grounds stated in the application. Stop. Since the petitioner's counsel is absent today, this court is inclined to give him one more chance so as to appear and contest this IA, if so advised. Registry to, therefore, list this matter again after 10 days by reflecting the name of Mr. R. Borua in the cause book.
Let's.
All right. Yes. IA for stay vacating. Is it not necessary to annex the order which is sought to be vacated? Why this IA has been registered? Who has registered this IA? Who has registered this IA? You please call for an explanation from this and take action against him. Yes, give it. Yes, Mr. Kalita. The affidavit is not on record, is it? The affidavit is not on, his affidavit is not on record.
Actually, I have just tag marked it, my lord.
Affidavit filed in the objection filed in the IA is on record.
Yes, yes. It is. I have just
My lord, because I filed a IA objection on 26/9/22.
Why are you repeating the same thing again and again? Nobody is asking when did you file it.
Oh, my lord.
The question here is it is
I have
not on
not checked
record.
up, my lord, the record. I have not checked that.
একদম লাস্ট হচ্ছে ফ্ল্যাগমার্ক করে দিছিল তোমরা আঠান আছে পেজ নাম্বার প্যারা নাম্বার 11 তো ইয়াতে লগাই দিছে লগাই দিছে
Mr. Kalita will have it on Thursday as a fixed item.
Yes, my lord.
Along with the objection.
Yes, my lord. Actually, wrongly tagged with this case, main case. That place, particular place, my lord.
But The court is very unhappy that this kind of filings have happened. We'll make an observation, whatever be the outcome of the order.
Actually, I was under the
No, no,
impression
no, this is
it is
not.
already in the order.
Can't be.
Next
You are,
time- next
we
time
will
we'll
not look into the file of another file and then appreciate your argument whether the order, what kind of a submission is this, Mr. Kalita? This can't be the,
Next time, my lord, we will correct
this
it.
can't be the way. This is not the norm. This has never been the practice in this court. And this will not be done by this court.
Actually, I thought, my lord, it was connected to the writ application, my lord. That's why I have not filed. Your lordship, in the middle portion, my lord.
Take it out and tag it with this. Yes. Please, argue.
My lord, then that conditional order, my lord, which my friend has already given. There was a direction, my lord, to deposit 5 lakhs of rupees, my lord. In the last para of order dated 27/4/22, my lord, considering the matter in its entirety, it is provided that the communication dated so and so shall remain suspended until the returnable date, and no coercive action be taken, subject to, however, deposit of rupees 5 lakhs before the respondent corporation. The respondent corporation shall not encase, that problem created here, my lord. The respondent corporation shall not encase the same without the leave of this court. My lord, they have deposited the check. And say validity of the check is 3 months, my lord. That was expired.
This is the one you're referring to, is it?
Yes, my lord.
But this says it is an affidavit in reply against the affidavit in opposition filed by the respondent numbers 1 and 2. And orally you are saying this is an objection filed in IA number 2939 of 2022. Both these two are not correct. Which is wrong and which is correct? Please, can you please enlighten us?
My lord, it is not there. Maybe my lord lordship has already checked, my lord. So may I pray, my lord, the matter may come up Thursday, my lord, including all the defects.
This is not the objection. You said this is the objection. This is not the objection. This is the affidavit in reply filed in WPC 2726 of 2022. And the IA is numbered differently. Have you filed any objection in the IA? When did you file it?
I filed on 26/9.
On the same day, no? Same day.
26/9.
Both, same day.
Is that objection on record, Mr. Kalita? Is it on record? His objection?
Actually, I got the copy, my lord. I have not checked in the record. That is in
Take down. Heard
I have
Mr.
seen
P. K.
another
Kalita,
affidavit.
Learned Senior Counsel, assisted by Ms. T. Goswami, Learned Counsel appearing for the applicant. Also heard Mr. J.I. Borbuya, Learned Counsel representing the respondent. Opposite party writ petitioner. First up, this IA has been filed with a prayer to vacate / modify the order dated 27/4/2022 passed by the Learned Single Judge in WPC number 2726/2022. First up, however, the order sought to be vacated / modified is not annexed to this IA. Be that as it may, Mr. Borbuya submits that an objection on behalf of his client has been filed on 26/9/2022, opposing the prayer made in the IA. First up, however, the said objection is not available on record. Since the applicant's counsel has expressed urgency in the matter and considering the nature of relief sought for in this case, registry is directed to tag the objection filed by the OP writ petitioner with the record of this case and list the matter thereafter on when do you want, whenever you want.
Any day, my lord.
Thursday, Wednesday, whenever. Which is more convenient for us.
Thursday, my lord.
Thursdays come. On Thursday, give the date as a fixed item. It is made clear that the IA will be taken up for final disposal on the next date fixed.
Interim order partially to be continued.
We'll say nothing on that. Why?
My lord, they have come for
No, but
vacating.
you have not deposited the check.
I have deposited.
Then
I
what
have
has happened?
deposited everything, my lord.
Then what has happened?
happened, my lord, the check got, maybe my lord, check got expired. They never written to us to give another, let them show a record, my lord. Single document they have written to us with acknowledgement. They never said.
You have given them the check of 5 lakhs.
Yes, my lord.
It is their receipt, my lord. I have given them later. It is their receipt.
That's all right. Interim order passed earlier to continue till the next date. Yes.
That actually, your lordship can dispose of the entire matter also, my lord. It is a very short matter, my lord.
Good.
Obliged, my lord.
In item 5, your lordship, service is complete. So far as newly implemented respondents have, my friend has, your lordship, filed a affidavit on dusty service, your lordship. Matter may be taken up for final disposal.
Today itself.
Lordship.
Let other matters go over then.
Lordship.
Mr. Chaudhary? I hope you will be available.
Yes, my.
This will take some time. This is a fishery matter.
It will take some time.
Let
And
us finish.
since my lord, I am, my lord, enjoying the fishery, I cannot object to that also.
Whatever, if we have to hear it, it will take some time.
Yes,
So
ma'am.
let's finish off the other
My-
shorter matters and then go into it. Yes.
my-
Yeah, please, your lordship. Lordship, on the last occasion, that is on 12/9, we were asked to take instructions to implead party to make insurance ombudsman a party. But shortly after that, the petitioner had to leave outside for his cancer treatment. So I couldn't get the paper signed by him. Can you give me some more time? It's a very genuine problem, your
What is
lordship.
the problem? Let us first see. You are appearing for whom?
The insurance lordship respondent.
What is the problem here?
In fact, lordship, this petition, lordship, this is relating to a policy and
Lordship, the petitioner had an insurance policy.
Why you need to implement the insurance ombudsman?
On the last occasion, the honorable court instructed me to.
Is there an order to that effect?
Yes, your lordship. Kindly see 12/9/22. Order dated 12/9/22.
Ombudsman decides the complaint made. Why ombudsman should be a party? It's like if you're challenging a lower court order, implicate the judge. Is it necessary under the law?
that was what the court said. My contention is that lordship, this writ petition before lordship is not maintainable because it is a consumer related case. If they are aggrieved by that, they have to approach, as per Sadhana law, they have to approach consumer court, not a writ petition.
But what is the controversy really?
Controversy, lordship, they had taken a policy and then his vehicle was stolen. And then he filed a petition before ombudsman. Ombudsman directed the insurance company to look into the matter and then decide. And then insurance company repudiated. Against that repudiation.
Why insurance company?
Because there is breach of trust and then he did not submit all the documents. To finalize the claim, lordship, the insurance company needs the documents. Those documents were never provided.
Which document was not provided?
On 3 grounds, actually, the year was repudiated. Abandonment of the claim as per policy condition number 7, because after 2 years, some months, he again approached after repudiation. Non-submission of vital document, original registration certificate, original fitness certificate, original permit, letter to DTO intimating the loss of the vehicle, and criminal breach of trust. Lordship, this will need adjudication. Evidence is to be led by him. So, lordship, this court cannot go into evidence and Yes, both the parties will have to lead their evidence if they are.
No, Ms. Majumdar, the vehicle was insured.
Yes,
There is no dispute about it.
Huh.
Vehicle got stolen.
yes,
There is also no dispute about
yes,
it.
yes.
So it is only a question of processing the claim. Correct? Was processing the claim.
Claim was processed, Lordship,
Hmm.
and it was repudiated. If it
Why
is
was it repudiated? That's what I-
repudiated on these three grounds, Lordship.
First count,
So if
please
it is
repeat again.
repudiated, Lordship,
Hmm.
they have to approach the consumer court.
No,
That is-
forget all these things. We have seen enough of this procedure. You tell us why the insurance company has repudiated.
Lordship, because they did not, it was repudiated on three grounds. That's what I've said, Lordship.
Yes.
Abandonment of the claim as per policy condition, that is policy condition number 7, because within a certain period of time, they have to inform give the documents and inform. If they do not do, then it is C. Then also non-submission of vital documents. And based on these only, the ombudsman passed the judgment that.
We'll hear and decide the case today itself. Argu.
Lordship, today, Lordship, let it come tomorrow.
Lordship may be taken at PM,
Taken at PM.
2 PM, Lordship.
What are these cases pending unnecessarily?
Lordship,
From
because
this
Lordship-
forum to that forum.
Lordship.
No, Lordship, the thing is, they have been taking time. Lordship will see from 19 adjournment by
And she
petitioner.
says the petitioner is a cancer patient. Is it?
Yes,
Who is a cancer patient?
the petitioner. After we communicated him about the impleading of the party,
Hmm.
then we came to know that he is leaving for outside and he will come back. That's the only instruction I have right now. But if only the good sir will allow us to argue, we can argue, Your Lordship. Because Your Lordship, this honorable court have this jurisdiction to
All right,
Take
all right.
this-
See, the point is simple. A vehicle which was insured, claim lodged, not settled. All right. One can go to the consumer forum and other forums. But can you say that the Reed court cannot look into the matter?
Yes, Lordship, because Lordship Sadhana law is very clear on
Is the
that.
law the Reed court cannot decide?
know, Your
Yes,
Lordship.
I'll
There is
just
a
read-
case for
I'll just read
shall-
what is, when there is,
Lordship. Finally, I.
No,
have
you
the-
please take your seat. You take your seat. Take your seat. Take your seat. Yes. Let us hear first what she has to say. You take your seat. Which paragraph of Sadhana law?
Lordship, para 6, 7. Three also, Lordship, because
Yes, please.
learned counsel appearing for the appellant urged that in view of the fact that under section 173 of the Motor Vehicle Act, a remedy by way of appeal to the High Court is available to the insurer against an award given by the tribunal, and therefore the filing of a petition under Article 127 of the Constitution was misconceived and deserved dismissal, and the High Court ought not to have entertained and decided the writ petition on merit. We find merit in this in the submission. Then Lordship, paragraph 6. The supervisory jurisdiction conferred on the High Court under Article 227 of the Constitution is confined only to see whether an inferior court or tribunal has proceeded within its parameters and not to correct an error apparent on the face of the record, which lays of an error of law. In exercising the supervisory power under Article 227 of the Constitution, the High Court does not act as an appellate court or tribunal. It is also not permissible to a High Court on a petition filed under Article 227 of the Constitution to review or reweigh the evidence upon which the inferior court or tribunal purports to have passed the order or to correct error of law in the decision. For the aforesaid reason, we are of view that since the insurer has a remedy by filing an appeal before the High Court ought not to have entertained the petition under Article 226, 27 of the Constitution. For that reason, the judgment and order under challenge deserves to be set aside. We accordingly set aside the judgment and order under appeal. The appeal is allowed. There shall be no order as to, however, it would be open to the insurer to file an appeal if it is permissible under the law. Lordship, when there is remedy, they are not supposed to come for writ jurisdiction. And also, Lordship, this also.
Reed jurisdiction will be barred, is it?
Yes. Lordship.
There is no such law which debars a reed jurisdiction.
Lordship.
This is
then
a rule of
Lordship-
prudence.
Lordship, let's also look into this Life Insurance Corporation and others versus Asha Goyal, Lordship. 50%. Because Lordship, then Lordship, what Ombudsman passed an order. Ombudsman passed an order based on the document. If jurisdiction is allowed, Lordship will have to say that the judgment passed by the Ombudsman was wrong. That's what Lordship has to do, that it was wrong and it is set aside. Then what happens, Lordship? Will it correct the documents they have not given, that they have delayed in presenting their case? Will that go, Lordship? That they have to prove by adducing evidence why the delay was caused and why it will not be covered by clause 7 of the policy.
Where is clause 7? Let us see.
That, well, Lordship, that's why, Lordship, the Ombudsman was, yes, so that the records are called, Lordship. Those were given in the before the Ombudsman, Lordship. And that, when that was asked, then she submitted that she will be making the Ombudsman a party in the case.
I did not submit it.
No.
Honorable Court had directed me to. It was not my submission, Your Lordship. Lordship,
Matters are pending since 2014.
Yes, Lordship. Recently, last week, same type of matter got disposed of in court number 19, because there also same the vehicle was stolen and the court directed that the case they have to file a case before the consumer court within 30 days of passing of the order, and then the consumer court will take up.
Where is the judgment?
Lordship, today, since they were supposed to file, that's why I said, Lordship, not today. I can bring it tomorrow. I can mention at 2 o'clock also. I can show, Lordship. Last week that case was.
Let us see at 2 o'clock.
Yes,
Please
sir.
bring that.
Fine, Lordship.
We'll see what happens. Call it up at 2.
Hello,
deeply obliged.
Yes.
As a matter of this matter, relates to a subject matter which is pending before the Supreme Court regarding as to whether SARFAESI Act is applicable to the property bank or not. One, and whether he is an agricultural land or not. There are 2 points pending before the Supreme Court.
So, what is to be done today? Adjourn it?
Maybe, I don't know.
You don't know. You are for whom?
I'm for our deputy commissioner, madam. Is there, madam?
You are for?
For the banks, madam, the apex bank. So we filed our affidavit.
So is the matter ready to be heard, and
Yes,
Mr.
no,
Bhattacharya is saying the issues involved in this writ petition are sub judice before the Supreme Court. Are you aware of it?
I'm not aware of such.
I'm not aware. SARFAESI Act, whether tree land is a agricultural.
Procedure under provisions of the SARFAESI Act. Whether or not a writ petition will be a maintainable matter, that issue has already been decided by the Supreme Court, matter. So numerous occasions. We've enforced our hypothecation and security. We've taken over management of the tea estate. Thereafter, under provisions of section 15, we've also appointed an agent, matter. That agent is now taking over, is running the tea garden, the company, and the loans or the profits generated therefrom are being used to discharge their liabilities, matter.
Well, give us some time, madam. Something has gone wrong with the tea garden, madam. In fact, just now I have been informed that, my lord, we could not take over the position because of the resistance from the tea garden. So, my lord, fix it next week, my lord. I will take proper instruction, ma'am.
Garden has been running by this petitioner long.
Seems to
There's
be,
no
because we
question of
wanted to
taking
take
over.
our position, my lord. They, my lord, resisted, violently resisted, but twice we tried, my lord. So, I'll take.
Mr. B.K. Bhattacharya, learned counsel appearing for the writ petitioners in all these cases, for the petitioner in all these cases submits that the issue as to whether provisions of the SARFAESI Act মোটে এখন দিয়ে দিব SARFAESI Act would be applicable in case of loan availed from a cooperative bank, and that too pertaining to agricultural land, is sub judice before the Honorable Supreme Court, and therefore until the matter is finally resolved, hearing of this writ petition will be adjourned. Full stop. Responding to the above, Mr. P.N. Goswami, learned counsel representing the bank, submits that some updated instruction in the matter is called for, and therefore this these petitions be posted again after 10 days as fixed items. Full stop. Mr. M. Setia, learned government advocate Assam, is also present on behalf of the official respondent. Taking note of the submission made by learned counsel for both the sides and as agreed to by them, let these matters be listed again after 10 days as fixed items.
Item 11.
Matter relates to non-payment of contractual bill. For construction of temporary barrack, with all necessary arrangement to accommodate 36 for personnel at Connery under Borpotha Police Station, Pardangno.
Yes, who is appearing for the respondents?
My lord, petitioner has filed another 5 writ petition, my lord. In all those writ petitions were disposed of, my lord, by the Honorable Court, my lord. In that folder, the petitioner did not complete the work. Petitioner has not started the work. Work order was issued to another person. They completed the work. My lord. This is the order, my lord.
I'm actually aware of that also. I have to go.
Same petitioner.
Yes,
All right. Let me see what is the order. You will get a chance to respond, don't worry.
Second personal. Supreme Police
Yes, so your client's 5 other cases have been dismissed on the ground that he has approached the court by suppressing material facts and he did not complete the work. You are not aware of this order. So you examine it, then we'll have it after 2 weeks.
Even manner, we have filed an affidavit, my lord. He had said that and he has not even started the work, my lord. Even my lord, he replied to our affidavit, he annexed a documents where it has been reflected that the person who has completed the work, whoever did the work, he has completed the work, my lord.
All right, let him examine, then we'll see.
Yes,
No order passed today. Yes. Heard Mr. M.J. Gogoi, learned counsel appearing for the writ petitioner. We have also heard Mr. M. Chetia, learned government advocate Assam, appearing for the respondent numbers 1, 2, 3. And Mr. J. Chutia, learned standing counsel KAC for respondent numbers 4 and 5. The petitioner herein claims to be a contractor by profession and has approached this court by filing this writ petition, seeking a direction upon the respondents to release his unpaid contractual dues of rupees 8,02,000. Stop. According to the respondents, the petitioner had never executed, never even started the work. But the same was executed by another contractor. As such, the question of payment of any dues to the petitioner does not arise, full stop. Mr. Chutia has also invited the attention of this court to the order dated 30/7/2021 passed by this court in WPC number 2191/2016 and the batch of connected petitions, inter alia contending that similar writ petitions filed by the petitioner have already been dismissed by observing that he had not executed the work and the petitions have been filed by suppressing material facts. First up, responding to the above, Mr. Gogoi submits that he is not aware of the order dated 30/7/2021 passed by this court. First up, on the request of Mr. Gogoi, this matter stands adjourned for 2 weeks so as to enable him to examine the order passed by this court earlier, dismissing 5 similar writ petitions filed by the petitioner. List accordingly.
Item 12. Item 12.
Yes, who is appearing in this case? B. Hussain, not there. What is this matter? Okay, so death of son of petitioner, will not dismiss it, will adjourn it. None appears for the petitioner when the matter was called up. Mr. M. Chetia, and government advocate Assam is present on the registry. Since the petitioner's counsel is not present today, this matter cannot be taken up for admission hearing. First up, registry to therefore list the matter again after 4 weeks.
Item 15.
Yeah, please.
Well, in this case, petitioner died.
Petitioner died. So then what do you want to do? What is the relief sought?
My lord, SARFAESI notice, my lord. Against the SARFAESI, my lord, they have filed this petition.
Died when?
My lord, exact date, my lord, I have taken instruction, my lord, over from.
You are also not.
No, I was just informed by the council.
My lord.
So then let him take steps for substitution.
Fine.
All right. Mr. S. Bothakul and counsel appearing for the petitioner submits that the lead petitioner in this case has recently died and therefore he be granted 3 weeks time to obtain instruction and file petition for substitution. First, Mr. R.K. Bhatra, learned counsel is present on behalf of the respondent bank and submits that he would have no objection if 3 weeks' time is granted.
My
Is
lord, my lord. In fact, my lord, there is one more thing which I'd like to point out.
Yeah.
My lord, we filed the wakalatnama in 2016. And thereafter, my lord, the affidavit has been filed by some other set of counsel. I could not file the wakalatnama also on record. Now, I also seek some time to seek instruction from the bank whether I need to continue or someone else will continue.
Mr. Bhatra, that you do.
My lord, we'll do it. Not.
Yes.
Hello, bless.
My lord, as per my instruction, my lord, some settlements going on between the parties, my lord. So, my lord, some time may be granted to take instruction, my lord, whether already settled or not.
I have no instruction regarding that. I am appealing for respondent number 789, my lord. I have to take instruction.
Mr. K. Sinha, learned counsel for the petitioner submits that talk of out of court settlement by and between the parties is going on, and therefore the petition be adjourned for 4 weeks, awaiting the outcome of such process. Miss
S. Musari for
S. For respondent,
3, 4, 5.
Ms. S. Musari has appeared for respondent numbers 3, 4, and 5, whereas Mr.
P. Bora,
P. Bora is present on behalf of respondent numbers
789.
7, 8, and 9. On the request of learned counsel for the parties, this matter will be listed again after 4 weeks.
Well, interim is there, that will be continuing.
Huh?
Interim is there. my lord.
Interim order passed earlier to continue. Just check it once. Yes.
Petitions before a lawsuit of flood affected fifteen landlord in district Dhubi landlord and Bilasipura subdivision landlord. The respondents have prepared the victim list landlord, the flood affected families, duly their name appear in the list landlord. Lordship may kindly see annexure B 77 landlord. This is the order passed on 16/12/13 landlord. Pursued the report by the subdivisional civil Bilasipura and on being satisfied the sanction is hereby accorded as per revised terms. My lord, amount was sanctioned, my lord. Thereafter again, my lord, in the next year also, my lord, it was in 13. Thereafter, page 79, my lord. No release of the amount, my lord. Again sanction, my lord. The same order, my lord. Sanctioning to 2 crores 31 lakhs 17,800, my lord. Thereafter, my lord, lordship may kindly see annexure D, page 80. In pursuance to High Court order, there was a direction to inquire into the matter, my lord. Lordship may kindly see paragraph 2. It is observed that the beneficiary list, my lord, was prepared as per the government rules after observing all formalities, that is after proper field verification by the so-and-so circle officer also expressed full satisfaction upon the said prepared list, my lord. Thereafter, in spite of that, my lord, lordship may kindly see annexure E, my lord, page 81. Fund is hereby released, my lord. But no payment is being made to the petitioners, my lord.
No, the name of this 3 petitioners are included in the,
Yes, beneficiaries.
they are beneficiaries.
Yes,
Which
yes.
page one says that?
Lordship may kindly see annexure A, page 15, their names appear in, as stated in my petition.
Annexure 8, page.
Annexure A, page 15, my lord, their names appear in serial number 714. Lordship may kindly 714. Then their names also appear in.
Which page? Give me the page. You are not prepared. Now you are
Not
going to find
prepared.
out.
714.
How much time you want? We'll adjourn the matter
Lordship
then.
may kindly see page 46. 7147, Shahadul Ahmed, Shahar Ali. And also Lordship,
Page 46.
yes, my lord, page
Yes.
46. Shahadul Ahmed, thereafter, my lord, page, serial number 1083, my lord, 1083.
Yes.
Yes.
That is on page number.
1083, my lord.
Page
Serial,
number?
serial number
1083 page, last page, my lord.
What is the number of the page?
Page number is my lord 60.
60.
Yes, my lord. The last, second last, serial number 1083, Asmat Ali. Page 60, serial number 1083.
So despite that, they have not been
No
given
relief,
relief.
my lord. They are, I am running from pillar to post, my lord. Again, they are.
But I appeared for response number 1 and 2, the Revenue and Disaster Management Department. We have filed an affidavit. What happened in this case, my lord, we have sanctioned the amount. It was released in favor of the Deputy Commissioner. Deputy Commissioner could not release the amount within time. So he deposited the amount before the government, my lord, government account. So therefore, we have requested the Deputy Commissioner to revalidate the sanction. That is lying with the Deputy Commissioner right now.
My lord,
That
that was
instruction
once done, my lord, revalidated.
My lord, I'll take instruction, my lord, whether you will revalidated or not, my lord, or payment has been made or not, my lord. Later, my lord, he had revalidated the amount giving to the petition amount because his name is there, my lord. I'll take instruction, my lord, that part has been done or
The
not.
2017 matter, you are still in the process of.
Yes, my lord.
We'll grant you time to take instruction,
Yes.
but at 2 p.m. Otherwise, we'll allow the writ petition and Deputy Commissioner will have to personally foot it. People cannot wait for 5 years, 7 years for these things. At 2 p.m. we want the instruction. You go and tell him.
My lord, my husband expired while in harness. He was working as a process surveyor in the SBGM in 2007. Thereafter, in 2007, he expired. Thereafter, I applied for compassionate appointment. That was processed.
Compassionate appointment now has been done away with. Now it's the pension, compassionate pension.
Even if that is granted to me, I'll be satisfied. What has happened in this case, my lord? My application was sent to the ESLR, then it to the state. Everybody cleared my application. Even the finance department also approved it. Thereafter, it was sent to the CGM for appointment. He said there is no sanction vacancy at the moment, so we can't. Even this continued up to 2017, my lord. In 2020, I came to know that some post has been applied, advertised, and therefore I came before the lordship for appointment. But they have filed their AO stating that this compassionate appointment has been done away with. 5% position is already filled up, and only thing that can be given is family compassionate pension. I'm being granted family pension, my lord, that is 7,500. But if the compassionate pension is granted, that would be better.
That will be higher.
That would be higher.
Yes, what do you have to say, Mr.?
So far as the vacancy position is concerned, there is no 5% vacancy. And so far as this compassionate family, only one rider is there, which is creating problem. That is the this 2017 OM is applicable only to the person who died on or before 31/3/2017. Lord, cut-off date given, page 31 of the affidavit.
Affidavit filed by
The response number 1, 2, and 3, my lord.
page 31.
Page 31, my lord. On or the scheme is applicable to those employees who died in harness on or after 1/4/2017. The new scheme.
And when did the petitioner's husband die?
He died on, my lord, 3/11/2007. And the scheme formulated by this honorable court, the previous scheme that I have annexed, my lord, annexure R2, page 17.
Annexure,
R2, page 17,
page 17 of your affidavit.
my affidavit, my lord. 3rd January 2017. This was in tune with the government of Assam OM of 2015.
The scheme has been superseded.
Supersede করেছে, কিন্তু যোনটো at the time of consideration যোনটো হ'ব সেইটো scheme
Yes,
So, my lord, the committee considered the case of the petitioner and recommendation, my lord, will find page 30 of the writ petition. The selection board examined the vacancy position in the establishment of Chief Judicial Magistrate Udalguri, but presently there is no vacant grade 4 post in the establishment. Board also unanimously decided that the appointment of so and so on compassionate ground will be considered as and when there will be vacancy in grade 4 post in the establishment of Chief Judicial Magistrate Udalguri. Now, at para 12 of the affidavit in opposition, relevant portion will be page 8. I have stated the cadre strength of grade 4 post in the CGM establishment is 17, and one post is already filled up by virtue of compassionate appointment by one Sri Manoj Kumar Das on 1/9/2000. Page 8, my lord, round about 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10th line from top.
so what is the position today in Udalguri?
As on date, my lord, there is no.
It can't be that she will not get benefit under this scheme or the previous scheme. That can't be the case.
Going by the date of death, my lord, the 2017 scheme, the circular issued by this honorable court, comes into play. The problem is 5% vacancy is not coming out, going by the cadre strength. One post arose in the year 2000, my lord, that was filled up, my lord. And this honorable court, Achyut Ranjan Das, I have stated in para 8 itself that if for want of vacancy 2 years the could not be considered, then it is considered as lapse. Para 7.10 of Achyut Ranjan Das, I have stated at page 8.
Anyway, you find out whether any vacancies are in the meantime during the pendency of this writ petition.
Lordships.
In the 5% category, whether any vacancy is arisen.
Yes, my lord, that I can do.
Yes, you may be justified there because Mr. Prasad, chances of your client looks very, very bleak. You must understand it. But let us see what is the condition.
My lord.
Will you find out?
Yes, ma'am. I'll try my
This
best.
is CGM Udalguri, is it?
CGM Udalguri.
Heard Mr. B. Prasad Laner, counsel for the applicant, also heard petitioner, also heard Mr. Iktas Laner, SCG, GHC, who submits that ordinarily cases of this nature would be covered under the new scheme for compassionate family pension notified by the government of Assam on 14/9/2017. But since the date of death of the petitioner's husband is 3/11/2007, she would not be covered under the said notification. Mr. Das submits that although there is a recommendation in favor of the recommendation by the selection board in favor of the petitioner for her appointment against a grade 4 vacancy in the establishment of Chief Judicial Magistrate, Udalguri, dated 2/8/2017. Yet, no such appointment could be made since there was no vacancy available under the 5% quota meant for filling up by compassionate appointment. Full stop. Mr. Das has, however, candidly submitted that he is not aware if during the pendency of this writ petition, any new vacancy has arisen against which the petitioner's case can be considered, subject to her meeting the rules, meeting the requirements of the law. Full stop. Taking note of such submission of learned counsel for the respondent, this court directs Mr. Das to obtain updated instruction and appraise this court on the next date fixed. This is the matter again after 3 weeks.
Highly please.
But difficult case, Mr. Das, Mr. Vikas. Difficult case.
Worship, on
Yes.
Lordship, on 29/4/2022, the review petition was directed to obtain instruction regarding, in spite of service of notice in the original second appeal, why they have not appeared. Till that they have neither, so many days are gone, Lordship, and they have taken any instruction.
We'll give him a last chance then.
Lordship.
None has appeared for the review petitioner when the matter is called up. Mr. M. Kalita,
D. Kalita, Lordship.
D. Kalita, learned counsel is present on behalf of the respondent and submits that despite availing repeated adjournments, the petitioner's counsel has not come back with instructions as to whether his clients did not appear despite service of notice in the connected second appeal.
appeal.
Full stop. Be that as it may, in order to give one last opportunity to the petitioner to appear and argue the matter, this review petition stands adjourned for 3 weeks, registered to list the case accordingly.
Item 21.
Yes, why you want adjournment here?
Lordship, my senior has some personal difficulties.
Difficulties means he has been taking adjournment one after another. Earlier also no representation, then prayer for adjournment, then again no representation.
Lordship, only for the day matter may be adjourned.
Your name, please.
G. Das.
Mr. G. Das has appeared for the review petitioner and sought adjournment in the matter on the ground that his senior, Mr. H. Das, is unavailable. After going through the record, I find that a number of adjournments have already been availed by the petitioner's counsel, and the ground on which prayer is made today is also not very convincing. However, for ends of justice, one last chance is given to the petitioner to appear and argue the matter. Registry to list this case again after 4 weeks.
Item 22.
My pleasure.
Yes.
That's it. This review has been filed basically on 3 points. First point is that this honorable court.
You have to speak a little louder.
Well, it is honorable court. While passing the impugned judgment in the original CRP, pleased to observe that my original suit was under Section 6 of the Specific Relief Act. Was not filed within 6 months. Lordship. But there is a specific issue regarding this of the line of trial court, that my suit has been filed within 6 months of my disposition of the land, Lordship. There is the first point, Lordship. And second point, that this honorable court, while passing the impugned judgment, Lordship, at page 37, para 14,
Having held as above, it is noteworthy that the parties have been litigating in respect of the same plot of land for over 3 decades, and the claim of the plaintiffs appears to one based on title. The suit raises heavily disputed question of ownership rights and possession set out by the both parties in respect of the disputed land, which in the opinion of this court is a matter that needs to be decided in a regular title suit by the following due process of law. But earlier, in an earlier round of litigation, Lordship, regarding the same subject matter and same lot of land between the same parties, a suit has been decreed in favor of me and right title interest and recovery of possession of the same scheduled land has been granted, decreed. Subsequently, Lordship, what happened after execution of the decree in the original title suit, I have been dispossessed from the suit land, and therefore I file a suit under Article 6 of the Specific Relief Act, Lordship. That is the question in this review petition, Lordship. Because in the earlier suit, Lordship, they have not prepared any appeal that attain finality, Lordship. There is a separate cause of action, Lordship, but that cause of action regarding for disposition of my.
Where is the order?
It starts from page 32, Lordship. Operative portion is 37, page 37, paragraph 14.
Page 37.
Paragraph 14, Lordship.
Just 1 minute. The court has said there is no specific finding on the date of this date and manner of disposition. Is there any finding, Mr.?
No.
Then what is wrong?
In my plaint, Lordship, everything has been written on the date of disposition.
No, but where is the finding of the court?
And issue number 2, Lordship, there's a finding, Lordship, because whether the suit has been barred by limitation, the minor trial court has held that I was disposed on so and so date. My suit has been instituted on subsequent date, that is within 6 months of disposition. That's it.
Where is it? Let us see. Which part?
Lordship, for that, Lordship, may kindly come to the record of the CRP, Lordship, that is on the CRP, Lordship, main CRP, 387.
Yes.
Impugn judgment, Lordship.
Hmm.
51, Lordship, start from page 51. Page 53, Lordship. Paragraph 8, issue number 2, limitation.
Page 50?
Page 53, Lordship. 53.
Yes.
Issue number 2, Lordship, limitation. May I read it, Lordship? In this case, defendant side alleges that the suit is barred under the law of limitation, but the defendant side in this case failed to show specifically as why and how the suit is barred under the law of limitation. As per the plaintiff, the cause of action of the suit arose on 8/10/87 when the defendant disposes the plaintiff from the suit land. To file a suit under Section 6 of the Specific Relief Act, the plaintiff are to file the suit within 6 months from the date of disposition. And admittedly, the suit was instituted by plaintiff on 21/11/87. Which shows that plaintiff instituted the suit within the period of limitation. As such, it appears that the suit has been filed by the plaintiff within the period of limitation. Hence, the suit issue is answered in affirmative and in favor of the plaintiff.
This is no finding on date of disposition. Mr. Kalita, there is no case for review.
Lordship,
Right.
regarding
That's it. That's enough. I have read the judgment. And then there was an order for appointment of Amin Commission by the court. That was
on
also not
that
done.
part, I will not go, Lordship.
No, but then you challenge the order. This is not a ground for review. Heard Mr. D. Kalita, learned counsel appearing for the review petition. Also heard Mr. D. Majumdar, learned senior counsel assisted by Mr. J. Lashkar, learned counsel appearing for the respondents, all the respondents, is it?
Madam.
Full stop. By filing this petition, the petitioner is seeking, petitioners are seeking review of the judgment and order dated 5/4/2018 passed by this court in CRP number 387/2015, allowing the revision petition with and directing the respondents stroke plaintiffs to seek relief in a regular suit based on title if so advised. Full stop. The judgment and order dated Five 2018 was passed in a revision petition filed by the respondents hearing, challenging the judgment and decree dated 31/7/2013 passed by the learned Munsif number 1, Dhubri in title suit number 32/1987, instituted by the petitioners as plaintiffs under Section 6 of the Specific Relief Act, 1963. Full stop. 1963, seeking restoration of their possession by alleging illegal dispossession from the suit land at the behest of the respondents. Full stop. After going through the materials on record, this court had found that there is no finding of the learned trial court to the effect that the suit was filed within 6 months from the date of disposition. Full stop. The court this court had also observed that despite there being a specific direction passed by this court by order dated 18/5/2004 for trial of the suit after fresh appointment of Amin Commission, no such step was taken before the learned trial court. Full stop. By referring to the impugned order, Mr. Kalita submits that although in respect of issue number 6, issue number 7, there is no finding as regards date of disposition and institution of the suit. Yet the learned trial court had in fact determined the said aspect of the matter under issue number 2. Full stop. As such, there is an error apparent on the face of the record, which calls for correction by reviewing the order dated 5/4/2018. Full stop. Insofar as non-appointment of fresh Amin Commission is concerned, Mr. Kalita submits that he is not contesting the aforesaid aspect of the matter. Full stop. Mr. Majumdar, learned senior counsel for the respondents, on the other hand, submits that there is no ground for reviewing the order dated 5/4/2018, in as much as the observations made by the learned, made by this court in the interim judgment are based on correct appreciation of facts. Full stop. In order to examine the validity of the submission of the petitioner's counsel, this court had gone through the observations made by the trial court with regard to issue number 2, which relates to the plea of limitation raised by the defendants stroke respondents. First up, the finding of the court below on issue number 2 are reproduced herein below for ready reference. Yes, sir. From the findings of the trial court with regard to issue number 2, I do not find any specific observation based on evidence on record as to the date of disposition and oblique or institution of the suit under section 6 of the Specific Relief Act 1963 by the review petitioners. Rather, the learned trial court had merely reproduced the version of the plaintiffs as projected in the plaint without recording any finding of fact. In any event, even the findings recorded with regard to issue number 2 does not specifically hold that the suit for restoration of possession due to illegal disposition was in fact instituted within a period of 6 months from the date of disposition. First, for the aforesaid reason, I do not find any merit in this review petition. The same is accordingly dismissed. Yes.
Liberty has been granted notice to file an appeal before.
Huh?
Liberty has been granted notice to file.
The Supreme Court will catch hold of you. You are seeking High Court's permission to approach the Supreme Court. You can always go to Supreme Court. We can help you if you want to go.
They are at liberty. With
Absolute liberty. Absolute liberty. You can go.
Deeply.
Yes. What are the 2 IAs, Mr. Kalita?
During pendency of the suit, lordship,
Hmm.
when they have started construction of a suit and but there will be instruction, lordship, because they have already
But
completed.
your clients have been given liberty to file a suit. It's a fresh cause of action. Section 6 is a very summary proceeding. It's a limited perspective. But the remedy is open to your client.
The problem is that lordship, right between the suit is between the same parties.
Hmm.
If I file another suit regarding right to the interest, there will be, I think, in my opinion, lordship, there will be come under section 11, lordship, res
That
judicata.
will be,
Come under section 11, lordship, res judicata.
No.
Because within the
you
same
are
party.
totally wrong. I think Mr. Majumdar will be gracious enough to even give you some learnings on that.
Lordship.
It is definitely not going to be hit by
In my
res
opinion.
judicata.
I may
Absolutely
be wrong,
not.
lordship. If the
Yes.
subject matter is different.
Absolutely.
section
It's a
11 will
new
not
cause
be
of
applied.
action. The High Court has given you liberty.
Right.
Where is the question of res judicata here?
I may be wrong, lordship.
Question doesn't arise.
Yep.
And in any case, the law is well settled that section 6 suit fails.
Regular
It is the same cause of action in section 6, which you can now avail here.
Absolutely. correct.
That's it. If there is no fresh cause of action, your section 6 will not be maintainable. By making this submission, if I record it, it will be detrimental to your client's interest.
Public.
Yes. Mm.
May I please, my lord? My lord, I am praying for adjournment for this matter.
That is what we have been doing.
My lord.
What is new about it? What is this matter?
My lord, I'm unaware about it, my lord.
Huh?
I'm unaware about it.
You are not aware. Very good.
My lord, can it come after a week? Because I cannot place that before the court, but this
No, but
information.
are you not appearing in this case?
No, my lord, I'm not.
Who is appearing?
My lord, Mr. A.S. Dillon, who was
Oh.
earlier in the chamber of Mr. S.P. Chaudhary. was-
Then he has asked you to seek adjournment.
Yes, my lord.
Huh?
Yes, my lord.
Where is Mr. Dillon?
He actually, my lord, he left High Court. He is not practicing anymore. So that is the reason, my lord. Only, my lord, a week time may be granted so that
He is not practicing.
he's practicing, my lord, but not in High Court, my lord. Maybe he's in Jorhat or.
But these are these grounds. 1st January onwards, we will dismiss on these grounds. You can't help it. These are all being recorded.
Yes, my lord, I understand.
The clients will also know what is happening. Your name, please?
My lord, K. Vishwakarma, my lord,
Mr. K. Biswakarma
on behalf of Mr. A.S. Dillon.
appears and makes a request on behalf of Mr. A.S. Dhillon, learned counsel for the petitioner, to adjourn this matter on the ground that the briefing counsel is no longer practicing in Guwahati, and therefore some time is required to make an alternative arrangement. First of, you're there, Mr.
Respond number 2.
Mr. J. Handick, learned standing counsel,
No, no, the government.
Government Advocate Assam is present on behalf of the respondent number 2. On the request made on behalf of the petitioner stroke applicant, this matter stands adjourned for 2 weeks. Yes.
Obliged, my lord.
May it please, my lord. No, this is a restoration application, my lord. What has happened is, my lord, the applicant before this honorable court is a ready-mix concrete plant, my lord. They have a plant in Pamohi.
No, what is this IA for?
My lord, the IA is for restoration. It was dismissed for default in 2019, my lord.
Which is the order? Which page?
If my lord takes up the IA 1245, the
Yes.
order is at page number 50, my lord, annexure A.
Yes. Why the petitioner was not present earlier?
My lord, it was a different set of counsels. In fact, after this order was passed, the insolvency proceedings were drawn as against the petitioner company, my lord. Now, during the insolvency proceedings, my lord, the resolution professional, while going through the documents, he in fact came to know that this matter is pending before this honorable court. And when the inquiries were made, my lord, we came to know that the matter has been dismissed for default. My lord, subsequently, the certified copies were applied for. And my lord, the
But
restoration.
why did the earlier counsel did not, was he asked not to appear?
No, my lord, that
Yeah.
I am not aware. In fact, the liaisoning officer, in fact, he also tried to get in touch with the earlier set of counsels, but he did not get any response, my lord. In fact, statement also has been made to that effect in this application, my lord.
So who is for the respondent?
My lord, GMDA, the copy has been served upon them.
So can you get the GMDA counsel? We'll pass the order after 5 minutes.
My lord.
Call them? Yes. 5 minutes, yes. Yes, who is the GMDA?
I'm sorry.
No objection.
No, no.
Heard Ms. N. Upadhyay, learned counsel appearing for the applicant. Also heard Mr. P. Nayak, learned standing counsel GMDA, appearing for the respondent numbers 1 and 2. First up, Mr. J. Handy, learned government advocate Assam, has appeared for the respondent number. Respondent number? Are you also appearing for 3? Three and 4, stop. 4. Respondent number 4. 3 no lage. This IA has been filed by the writ petitioner as applicant with a prayer to set aside the order dated 13/2/2019 passed in WPC number 5528/2012, whereby the writ petition was dismissed for non-persecution, first of. By referring to the explanation furnished in the IA, Ms. Upadhyay submits that the learned counsel could not remain present on that day due to a communication gap arising out of circumstances which were beyond the control of the applicant and therefore the control of the applicant. Stop. As such, if the writ petition is not restored, the same would cause serious prejudice to the interest of the applicant. Mr. Nayak and Mr. Handick submit that they do not have any instruction to file objection and therefore would not oppose the prayer for restoration of the writ petition. In view of the above, and by taking note of the explanation furnished in the IA, this court is of the opinion that a good case for setting aside the order dated 13/2/2019 and restoring the writ petition to its original file has been made out by the applicant, ordered accordingly. Registry to list the writ petition for necessary orders after 3 weeks. I stands disposal.
Highly obliged.
Madam 26.
May I please lordship. Lordship, this is for restoration of writ petition number
2787.
2787 lordship. 2787 lordship.
Which order you want?
Lordship 16/2018, last page, lordship. 16/2018.
Yes. What is the explanation?
Lordship, on this, that the Angus Council was not in Guwahati lordship. As such, he cannot appear before this lordship.
So, if the English council is not there,
And the daily list was escaped from his notice, lordship. That's why he could not appear before this court.
yes, Mr. Hendrick. Yeah, what is your name?
M.H. Soikia, lordship.
M.H.?
M.H. Soikia.
Mr. M.H. Silken and Francis to the applicant. Also have Mr. G. Hendrick, learned government advocate Assam, appearing on behalf of the
1, 2, 3, 4, 5. 5 and 7. 5 blocks. 1, 2, 3, 4, and 5.
Then the other respondent notice has to go there.
Lordship.
Appearing with so and so, so and so. Issue notice upon the remaining respondents returnable in 4 weeks. Steps by registered post to TD.
Madam 27. Madam 27.
Also a restoration petition, but there is a delay of 881 days.
Mr. Jailers, will issue notice.
And my lord, in this case, my lord, respondent number 1 and 2, my lord, Power Grid is represented by senior advocate NC Dash, my lord. So I may be allowed to start.
Respond numbers?
1 and 2, my lord.
Yes.
Standing counsel, Mr. NC Dash is appearing, my lord. So
His name not being shown in the list.
no, I will start the copy, my lord. So
Then let the matter be listed by showing his name. He has to
Yes.
accept notice.
Yes.
Solving will not do. NC Das, standing counsel.
Power Grid Corporation of India.
Either we have this matter by showing his name or you have to take steps. Which do you want? Quick.
So my lord, I will serve him copy, man.
On the request of Mr. J. Raskol, I am counsel for the applicant. Let this matter be listed again after a week by reflecting the name of Mr. NC Das, Learned Standing Counsel PGCL in the cause list.
My lord, government is there, my lord, 3 and 4.
As Mr. J. Hendrick, Learned G. Assam is present on behalf of the respond numbers
3 and 4, my lord.
3 and 4.
3, 4, and 5.
3, 4, and 5. Yes.
Obliged.
Madam 29.
Yes.
Well, the matter has been disposed of on 27th 2022. In this petition, my lord, the respondent number 5 has to be written as the executive engineer, water resource department, Guwahati, West WR division instead of East division. That is correction to be done. Page number 85, my lord. No. 141. 141. Bishop James, 141. Page number 141. Page number 141, respondent number 5, my lord. Guwahati, executive engineer, Guwahati, West division, Borolomu, Guwahati 9 is to be done. Instead of executive engineer, water should Guwahati.
This is a common order. This is not order pertaining to any individual. The respective authority, the concerned authority is to do it. This is a common order passed in a batch of writ petitions. How many? Some
153. Total 153.
yes, yes.
Out of those, in two cases, my lord, the name of the respondent number 5, my lord, all the things are okay, but the east to be west, made it west.
East to be made west. Where is it written? East in the order.
Page number 141, my lord, respondent number 5, my lord.
Page number 141.
Yes, my lord.
That is from the petition. You have written it in the petition that way.
That's
No, that can't be.
reflected on the.
If you made a mistake, why the order of the court should be corrected? Huh? No, you submit a copy. They will do it. If they do not do it, then you come, we'll see. It is your mistake. If you've written wrongly in the petition, why should we correct it? How can the court correct your petition?
All things are okay, but.
All right, your name, please.
My name DK Jain.
Heard Mr. DK Jain, learned counsel for the applicant, also heard.
P.
Kakoti on behalf of B.
Goswami.
Huh?
P. Kakoti on behalf of B. Goswami.
P. Kakoti, learned counsel who has appeared on behalf of Mr. B. Goswami, learned additional AG Assam, appearing for the Water Resources Department. This IA has been by the order dated 27/9/2022, as many as 159 writ petitions expressing similar grievance were disposed of by this court by issuing certain common directions. Full stop. The instant IA has been filed with a prayer to correct the order dated 27/9/2022 insofar as it relates to the designation of the executive engineer
Yes,
who is concerned with the petitioner's applicant's case. Full stop. Mr. Jain submits that the concerned executive engineer of Water Resources Department handling the petitioner's, handling the applicant's case would be executive engineer,
Guwahati West Division.
Water Resources West Division,
West Division, Borolomu, Guwahati 9.
Volume of Guwahati.
9.
But in his writ petition, it has been mentioned as East Division, within quotes, East Division. First of- After hearing the submission of Mr. Jain, it is apparent that by filing this IA, he is not seeking correction of the order of this court, but correction of a mistake made by the writ petitioner in drafting the cause title of his writ petition. First up. Be that as it may, since the tenor of the order is tenor T1 of the order passed by this court is of such nature that all the concerned officials would be required to play their part in complying with the order. I do not deem it necessary to pass any further order in this IA, save and except observing that the respective authorities connected with the concerned petitioner shall do the needful for compliance of this order. IA stands disposed of. Yes, next matter, please.
Similar.
Huh?
Same, east has been written instead of west. Similar method. Similar order may pass.
Here, east and west, same,
Same.
everything is same.
Same mistake has been done in both the.
Same order. Dispose of.
Delay condonation petition for, my lord, delay condonation petition for substitution of petition number 2 who died on 17/11/2021. And there's a delay of 121 days.
Notice has to go.
Yes,
Will issue notice now?
the government is appearing, only government. my lord.
Is there any private party?
No, private.
Sure. So, what is your stand? No, condonation of delay of 121 days. Delay can be condoned. We'll condone the delay then. Have you served them copy?
Yes.
Substitution also.
Yes.
All right, you take down heard Mr. M. Khatonier, learned counsel appearing for the applicant. Also heard Mr. Miss N. Bordoloi, learned standing counsel, Revenue Department, Assam, appearing for the respondent.
1, 2, 3.
Respond numbers 1, 2, and 3, and Mr. J. Handik, learned government advocate, Assam, appearing for respond numbers 4, 5, and 6. Good stuff. Good stuff. The writ petitioner number 2 in the connected proceeding, namely Jyoti Prasad Khadria, KHADRIA, died on 17/11/2021 during the pendency of this writ petition. First up, since there is a surviving cause of action in respect of the deceased petitioner, hence the writ petitioner, hence the legal heirs of the petitioner number 2 have approached this court by filing this IA with a prayer to condone the delay of 121 days in filing this substitution petition. Stop. I perused the grounds taken in the IA. First up, Ms. Bordoloi and Mr. Hendrick submit that they do not have any instruction to file written objection, and therefore the prayer may be allowed. Full stop. After going through the explanation furnished in the IA, this court is of the opinion that the applicant was prevented by sufficient, the applicants were prevented by sufficient cause from filing this IA within the period of limitation. As such, the delay of 121 days is hereby condoned. IA stands disposed of. Where is the other IA?
Other is 339.
So substitution by whom?
By the the legal heirs of the writ petition number 1, my lord. And writ petition number 2 was the constituted attorney of writ petition number 1 partnership firm.
Petitioner number 2 was the attorney.
Attorney for the case, my lord.
So you want him to be substituted.
Substituted by the new attorney.
That cannot be done.
My lord,
Once the person dies, the power of attorney lapses.
yes, well, a new power of attorney has been given by the legal heirs.
Why a power of attorney holder need to be substituted?
Because all these partners of writ petition number 1, my lord, it's a partnership firm. My lord, the partners live in different parts of the country, my lord. So one of the partners, that is writ petition number 2, was a partner. So he died, my lord. Now the other partners are constituting the legal heir of partner number 2, who gets their right in the
So
partnership.
partnership has been reconstituted.
Yes, my lord. Partnership is a continuing partnership because the legal heirs are included in it.
I will record that you have no objection, and that will preclude you from raising any objection during hearing.
Then I have to file an objection regarding that.
We don't know, because now you will schedule and say no objection. Later on, you will bring in a big lawyer for government and he will start arguing. This tamasha we will not allow anymore in the court. If you do not object, we'll record, and it will foreclose your right to object on this for future.
Partnership, the main case is, my lord, the partnership firm. They owned a tea garden, my lord, that was acquired in 1956, but no acquisition proceedings were done, my lord. And it was continuing like that. They have been paying the revenue from all these years, my lord.
No, no, Mr. Khatune, you may be right.
Yes.
You may be right on that. But you have certainly not given those facts before the court at the moment. In your IA, it is not there. We don't have any problem in passing that order, provided they say that they don't have any objection.
Yes, ma'am.
Otherwise, the trend is now that now get rid of this. Some other date will raise all this plea and then ask the judge to work on this. This is not going to work. If they don't want to file an objection, we'll record it. And this matter will be closed for once and for all.
All our partners. One partner.
So you don't have any objection. I'm allowing it. Yes, give it.
Other partner.
Heard Mr. M. Khatune, learned counsel, M. Khatune, learned counsel for the applicant. Also heard Ms. So-and-so for the OP numbers 1, 2, and 3, and Mr. J. Khatune, and J. Hendrick, learned counsel appearing for 4, 5, and 6. By filing this IA, a prayer has been made to substitute the legal heirs of deceased writ petitioner number 2, late Jyoti Prasad Khadria, who died on 17/11/2021. First of, Mr. Khatune submits that the predecessor in interest of the applicants was one of the partners which is
Petition number 1, my lord.
which is one of the partners in writ petitioner number 1, and therefore the applicants have a substantive subsisting legal right in this matter. First of, it is also the submission of Mr. Khatune that save and accept the applicants, there is no other surviving legal heir of the deceased petitioner number 2. First of, Ms. Bordoloi and Mr. J. Hendrick, learned counsel appearing for the opposite parties, submit that they would not have any objection if the prayer for substitution is allowed by this court. In view of the above and taking note of the statements made in the IA, the prayer for substitution made by the applicants is hereby allowed. Registry shall incorporate the name of legal heirs of late Jyoti Prasad Khadaria as mentioned in para 2 of the IA in his place by making necessary endorsement in the cost title. First up, IA stands disposed of. Yes.
Hello.
Item 4 and 5.
Baki, the hearing also now hearing cases are there. Partner matter. Yes, so there is some partner matter.
We get precedence.
In item number 33, my lord, my senior Mr. P. Monta appears, my lord. He is down with fever today, my lord. May I pay the matter will be taken up next week, my lord. That young boy matter, my lord.
Lordships, I've got the instructions from Asalsa. They're very dismal instructions, unfortunately, saying that Asalsa is not really a party respondent and they do not have the jurisdiction to pass any orders or look into the matter. But if this honorable court passes any particular orders in the matter, they're willing to comply with it. That is the only very short and concise instruction in the matter. But I can address your lordships on the fact as to how perhaps this honorable court can take the matter forward. Maybe.
All right, you act as an amicus then in
I
this
do not
case.
have any difficulty with it. Maybe Friday after your lordship's convenience or Thursday. I have no difficulty with it. I'm at your lordship's disposal.
It will be next week.
Next week, lordships.
A prayer for adjournment has been made in this case on behalf of the writ petitioner on the ground that the arguing counsel, Mr. P. Mahanto, is unwell and therefore has not been able to come to court today. First of Ms. R.S. Siroti, learned counsel for the Asalsa and so for the government of Assam are present and do not have any objection if the prayer is allowed. Registry to therefore list this matter again in the next week as a fixed time. Yes.
May I pay the matter will be kept as part heart, my lord.
It is part of it.
And a fixed date, your lordship, subject to your lordship's convenience. Monday or Tuesday after your lordship's convenience.
You put the date of Thursday, next Thursday,
Next Thursday, lordship.
subject to availability of the bench. What is Thursday?
1st of December, perhaps, your lordship.
Next Thursday.
Next Thursday would be. Huh? Goodness, can I?
Next Thursday, 1st December? Yes,
1st
1st
December,
December,
1st
subject to availability of bench.
Hmm.
Yes. Yes.
Item number 34.
Hmm.
With the consent Milord, any other day, Milord, can I have it?
All right. As paid for by land council for both the sides, this matter stands adjourned for 2 weeks, list accordingly. Yes. It will last again. It will last 8 minutes. Yes, please.
Lordship.
Is this a parted matter?
Lordship.
Your Huh?
Lordship has heard that the second item, item number 5 is ordered. Item number 4 is. 4, your Lordship, 4 is ordered.
These are bench 4 matters. Why,
Yes.
why shouldn't it go to the bench 4, regular bench 4?
Because it is ordered. Your Lordship.
We'll release it.
Your Lordship, can your Lordship dispose it of?
We'll fix it on next Tuesday. Or Thursday before this is not a regular bench 4
Your Lordship have substantially heard already, your Lordship.
and substantially forgotten also.
I leave it to your
If this is not concluded today for some reason, you'll have to wait for many weeks. I'm telling you.
Lordship, probably it will not take much time, your Lordship.
Yes, start please.
Lordship. I will at least not take much time, your Lordship. I don't know about it.
All right, how many writ petitions?
2, your Lordship.
It may take some time for me, madam. It may take some time for us, my lord, because there are too many things I have to project, my lord. If it is not inconvenient, my lord, as your lordship has said, my lord, it can be taken up next week, convenient, my lord, in a convenient date for all, my lord, because there are things which I'll have to place, my lord. It will take time, my lord.
Yes, but this bench is only for today.
Yes, my lord. Same reason, my lord.
After that, it could be 15 minutes, half an hour bench. For the rest, even if it happens, this year you are not going to get this bench. Single bench, most probably, that's the rostering. So you will get stuck up, Mr. Bothakur.
Otherwise, your Lordship, small issue is
No,
involved.
small means we'll
What-
have to start from the beginning.
Lordship, that's.
And you are small, he is saying he'll need some time. Let it go before the regular bench.
I leave it to
We'll
you.
fix it on Thursday. In view of the urgency.
Lordship.
I had Mr. S. Bothakur, learned counsel for the writ petitioner in WPC number.
Item number 4, my lord.
Item
Item
number
4.
4, your Lord, 3215.
And Mr. H. Buragway, learned counsel appearing for the petitioner in item 5. Full stop. Mr. D.K. Sharma, learned additional senior government advocate Assam is present on behalf of the official respondents. Full stop. Mr. M.K. Chaudhary, learned senior counsel, assisted by Mr. M. Sharma, has appeared for the respondent number 4. Full stop. It is submitted at the bar that this matter is ready for hearing and both these writ petitions can be taken up for final disposal. Full stop. These matters pertain to civil bench 4 and has been civil bench 4. Full stop. Since there is urgency in the matter and the availability of this single bench in near future is not certain. Hence, taking note of the submission of both sides and acting on the request of the petitioner's counsel, registry is directed to list both these cases again on
24th.
Thursday, 24th of November 2022, before the regular bench as fixed items. These writ petitions shall no longer be treated as parted before this court.
Okay.
My lord, in item number, next item, my lord, I am for respondent number 5.
Which one?
The item, my lord, respondent number.
You are
5.
for respondent number 5 in both the
No,
items.
my lord, in the first item, respondent number 4, in the release item, my lord, item number 5.
Respondent number 4/5. Readable. Yes. Which are the other matters? And What is item 18? Let us see.
Item 18.
Acha, all right.
I have informed my lord.
You get the instruction. We'll come back at 2.
Yes.
Later, what are the facts? Let us see the facts.
Yes, Your Lordship. To look at the prayer, what is their prayer? And I got the other order, Lordship, that was passed.
Where is the order by which the insurance claim was repudiated? Which page?
And except for page 19, Lordship. This is his letter. I think they have not annexed that, Lordship.
It is annexation number 7, Your Lordship.
Annexure,
7, Your Lordship.
page number.
Petition number 24.
What is the page number?
23, Your Lord. Main petition 23. Your Lord.
No, that's
No,
the
this is the order.
insurance ombudsman. You take your seat. You take your seat. I'll ask you when the time comes. You take your seat. Yes,
That repudiation letter, I think they have not annexed, Lordship.
let us see what is the banking ombudsman's order.
Yes, Lordship, that last order, the annexer
7.
seven,
page
yes,
22,
Lordship.
Yes,
I'll read the whole thing.
yes.
Page 23. The complainant petition is filed against the above insurer for total repudiation of the claim under policy number so and the same has been admitted under Rule 12(1)B of the RPG Rules 1998. Facts submissions. Complainant. The complainant stated that the Tata Indica car bearing registration number so belonging to him was insured with above insurer covering the period from 31/8/2006 to 30/8/2007. During the policy coverage, the vehicle was missing along with driver since 14/10/2006. He informed police on 18/10/2006 as well as the insurer about the loss of the vehicle. The complainant has thereafter lodged a complaint for loss of the vehicle before the insurer being supported by all relevant documents, but the insurer has repudiated the claim without any just ground, feeling aggrieved this complaint is lost. B. Insurer. The insurer has contended in their self-contained note that a passenger carrying commercial vehicle bearing a policy number so and so was issued by them to Mr. Jai Chandra Burman with policy period from 31/8/2006 to 30/8/2007. But the vehicle was registered in the name of Jai Charan Burman, and all documents are signed as Jai Charan Burman. Insurance proposal form was filled as Jai Chandra Burman. On 26/10/2006, Mr. Jai Charan Burman intimated them that his vehicle bearing registration number so and so was hired on 14/10/2006, and the vehicle was not returned. The intimation was late for 12 days. An FIR was lodged with Paltan Bajar PS on 18/10/2006, stating that one person having mobile number so and so hired the vehicle from Muhammad Alam Hussain, the driver of the vehicle, for 1 day for going to Nagaon, and the driver was caught and the vehicle was taken by the person who hired the vehicle. The case was registered under Paltan Bajar PS under FIR number 59606 under section 392-342 IPC. But in the FR, it is noted that Sujit Kumar Saikya, Inspector Paltan Bajar PS, has reported that there is no evidence found that the driver was caught and then the vehicle was stolen. Moreover, it is presumed that Muhammad Alam Hussain, the driver, has stolen the vehicle and shifted to Bihar along with his family. As per the written statement of Mr. Jai Charan Burman, the driver was missing along with the vehicle. They requested the complainant to submit some documents on 14/7/2007 and 22/5/2007. Final reminder was given on 11/7/2007 for submission of the documents within 5 days of receipt of the letter. Otherwise, the claim shall be treated as no claim. Ultimately, on 31/07/2007, the claim was closed as no claim for non-submission of documents. But the complainant submitted some documents along with his letter dated 17/4/2007. Original registration certificate, original fitness certificate, original permit letter to DTO intimating the loss of the vehicle, having received seal and signature are the vital documents to prove the incident of theft were never submitted. On 26/3/2010, the complainant requested us for reconsideration of the claim without submission of the documents, that is, after 2 years, 7 months, which attracts the policy condition number 7. Finally, the claim was repudiated, the claim on the following grounds: abandonment of the claim as per policy condition number 7, non-submission of the vital documents, original registration certificate, original fitness certificate, original permit, letter to DTO intimating the loss of the vehicle, criminal breach of trust by the insured employee, that is the driver. Hearing. Both the sides are called for a hearing on which date the complainant appeared personally and the insurer was represented by Mrs. Madhuchanda Dhar, AM, Oriental Insurance Company Limited. Their statements were recorded. They were also heard in person. Decision. I have carefully gone through the entire documents available on record as well as the statements of the parties. It is an undisputed fact that the vehicle bearing number so and so belonging to the complainant was insured and covered under the above policy. Lodging the claim for the loss of the vehicle on 14/10/2006 due to theft has also not been disputed. The self-contained note of the insurer referred to above goes to show that the policy bearing number so and so was issued in the name of Mr. Jai Chandra Burman, and insurance policy form was filled by Sri Jai Chandra Burman, but the vehicle was registered in the name of Jai Charan Burman. It is presumed that there might be typographical mistake in the middle name of the insured. First name and the title were same between the policy and the registration certificate. Whatever it may be, the policy in which the claim was lodged was duly issued by the Adgaon branch of the insurer, and the claim appears to be covered under the said policy. The copy of the letter dated 19/10/2012 issued by the insurer, Annexer K, also makes it clear that they have repudiated the claim on the following grounds: abandonment of the claim as per policy condition number 7, non-submission of the vital documents, original registration certificate, original fitness certificate, original permit, letter to DTO intimating the loss of the vehicle, criminal breach of trust by the insured employees, that is the driver. It appears from the self-contained note as well as from the statement of the representatives of the insurer that the complainant, Mr. Jaicharan Burman, made request for consideration of his claim without submitting of documents on 26/3/2010, that is after 2 years, 7 months, which attracts the policy condition number 7. The insurer has produced the copy of request letter dated 26/3/2010 of the complainant and the terms and conditions of the policy before this authority, which are marked as Annexure J and Annexure L respectively. On perusal of the Annexure J, it is clear that the complainant could not submit all the claim papers before the insurer due to non-receipt of police final report. On a close perusal of Annexure 1L, it is clearly mentioned in condition 7 of the policy terms and conditions that the company shall disclaim liability.
Mr. Deka, I can almost clearly hear what you are consulting. 2 hearings can't go on. Either we stop them and because the acoustics of this room is very, very, yes.
Policy condition that the company shall disclaim liability to the insured for any claim here under, and such claim shall not within 12 calendar months from the date of such disclaimer have been made of a suit in a court of law. Then the claim shall for all purposes be deemed to have been abandoned and shall not thereafter be recoverable hereunder. It is ample clear from the above that the complainant made request for consideration of his claim after a gap of more than 2 years from the date of no claim, which is clear violation of the policy condition number 7. The insurer alleged that the complainant has not submitted the original registration certificate, original fitness certificate, original permit, letter to DTO intimating the loss of the vehicle. It is an admitted fact that the original documents of the vehicle always keep in the vehicle to avoid the security check or any other administrative purpose. In the instant case also, the complainant kept his original documents in the vehicle for which he lost his original documents along with the vehicle. In that circumstances, the insurer cannot insist the original documents of the vehicle if the insured produced the certified copy of the required documents of the concerned authority. The insurer also alleged that there is a criminal breach of trust by the insured, that is the driver. It appears from the copy of Ejahar along with FIR, Annexure D, that the complainant informed the police that on 14/10/2006 at 9:30 p.m. one telephone received by his driver, Muhammad Alam Hussain, from passengers requested him to go to Nogao, and on the way to Nogao, the said passengers caught his driver and then his vehicle was stolen away. On getting Ejahar from the complainant, the police registered a case under Paltan Bajar PS under FIR number 59606 under section 392/342 IPC. However, it is apparent from the copy of police final report that during investigation, there was no evidence found that the driver Muhammad Alam Hussain was caught. The police presumed that the driver Muhammad Alam Hussain had stolen away the vehicle and fled away to Bihar. Finding no clue of the vehicle, they have submitted the final report and forwarded to the CJMK Guwahati for acceptance of the FR. The complainant has also stated in his statement that on 14/10/2006, the driver Muhammad Alam Hussain took the vehicle with passengers to Nogao, and from their vehicle was missing along with the driver. It is crystal clear that the copy of the police final report that the driver Muhammad Alam Hussain of the insured vehicle of the complainant had stolen away the vehicle bearing registration number so and so. Therefore, it is a criminal breach of trust by the insured employee, that is the driver. It is proof that there was serious lapse on the part of the complainant. Considering the entire facts and circumstances as discussed above, I am of view that the insurer has rightly repudiated the claim of the complainant. Finding no ground to interfere with the decision of the insurer, the complaint is dismissed and is treated as closed. Let the copies of this order be sent to the parties immediately. So let's say that was.
So where is the insurance contract agreement policy document?
Policy document was produced before learned ombudsman lordship, because that is marked as Annexure L. Lordship.
Right.
So that document is there.
Where? There means where?
Before ombudsman, because that was produced, that was marked as, I just read it is marked as L, Annexure L.
No, please tell me one thing. The insurance company wants the original documents.
That the learned tribunal has negated for us, that
And what is this breach of trust?
uh,
What does it mean?
breach
The
of trust
driver
means
of the vehicle, for some reason, steals the vehicle, goes away. So the claim will not be maintainable.
that is lordship there, because breach of trust, that is one of the policy condition. And the number one thing was that he was asked to present his documents and everything, but he did not. And after 2 years, 7 months, he again filed the letter with so that goes for abandonment. That's what.
But you have asked for documents which you could not have asked for. What do you say
No.
about that?
No, lordship, for that he has to give us the
He
explanation.
did not lodge the claim before 2 years.
No, he initially he lost the claim after 12 days.
Okay.
Then he was asked to give the documents, lordship, on 2 dates, 14/7/2007 and 25/5/2007. Final reminder was given to him on 11/7/2007 for submission of documents within 5 days.
Correct.
And he ultimately he did not do, and even from 11/7, though it was mentioned that 5 days, but ultimately on 31/7 of that month, July month itself, after 20 days, it was declared as no claim. Then again, he writes that letter on 26/3/2010. From 7 he has kept quiet, and 10 he writes that letter.
No, but what is he expected to do? You are asking for documents which are not in his possession.
But then, lordship, if they are not in position, he has to communicate, lordship. The time is given, so he has to communicate with the insurance company. He does not give anything. And in 2010 again.
These are very, very flimsy grounds. Once
But-
he has
but
lodged
his-
a claim, it is only his duty to communicate. And in any
No,
case,
lordship, when the documents are asked for, even if he doesn't have the documents, lordship, that he has to tell them that these documents are not, they were in the vehicle or whatever, he has to.
all right, but now the ombudsman has rejected that ground and there is no appeal by the insurance company against that.
But
So
lordship.
that
the-
argument you can't make now.
No, I'm not making lordship. What I'm making is the abandonment, that after.
Follow what I am indicating is that there has been no abandonment of claim because the ombudsman has ruled against the company, insurance company on that point.
No, on that point, on the point number 2, non-submission of vital document, lordship. Abandonment, the ombudsman has accepted, lordship. Vital document, the ombudsman says that these were in the vehicle. So that page 27, lordship.
All right, the point is without the policy document, a final decision will not be possible. We'll ask the registry to requisition the records and list this again as part of matter.
Lordship. And I got the other quote.
Sorry?
In the morning, I said last
Yes.
week only another. Also, there was theft, lordship, and they filed a writ petition just like this, and it was in 2013. And the
Lordship, I have annexed the policy, your lordship.
You are next.
Yes, your lordship.
no policy, no. Court is asking about the policy condition.
Lordship, the 2 things, your lordship. First of all, kindly come to annex number 2, your lordship. 14, that is the policy they made with me. And your lordship, I have provided the esteemed court with a copy of the policy, your lordship. You have the policy red flags and flag mark. your lordship.
No, you have the policy. That is not in dispute.
Yes.
Where are the terms and conditions?
Sir, that I have submitted before the books of your lordship. It is red flag mark. your lordship. I have submitted, your lordship. I think it's the last red flag, your lordship. Last or second last name.
Yeah, they be an amicus.
No, I think more sure the company policy. Could you find it, lordship?
Yes, which page you, show me which page?
La. Case number no. Lordship, the Oriental Insurance Company Limited's commercial vehicle package policy, Your Lordship. I have provided a copy, Your Lordship. Red flag mark, Your Lordship. Lordship,
So theft is also is covered. Theft is covered.
theft is covered. Your
Then what is this breach of trust business?
Lordship, because Lordship, breach of trust is the driver, the trust, the owner trusts the driver with the vehicle. And if there is a breach of trust on that point, because here, Lordship, what is the final report that the driver has taken away the vehicle and he has gone to what the owner is saying.
So the owner is responsible for that.
That is the policy condition.
Lordship,
But our High Court has given, on breach of trust, our High Court has given judgment that it can be entertained. But Lordship, their petition itself, Lordship, what are they asking? The Ombudsman has rejected their claim. They are not challenging that person.
Okay, these are very hyper technical things.
No, it is not a question of hyper technical, Lordship. How Lordship will now assess? That's why on the judgment I have given Lordship last week judgment, and that also how the court will assess what is the loss, Lordship.
That we are not going to do it. We are not going to do it. If we find that the miss, please take your seat, or else I will adjourn it to January. When the court is with you, you must have this basic courtesy. Take your seat. We are not going to decide what amount, what, etc. If we find that the repudiation was valid, then we'll dismiss the petition. If we file it is invalid, then we'll give reasons and ask the insurance company to process the claim and settle it within a time-bound manner. Or that outcome of that settlement, if there the insured is unsatisfied with some amount here and there, that could be a subject matter for the consumer court case. But it can't be that if the decision making appears to be arbitrary.
But Lordship, one Ombudsman has already accepted.
We'll set
that.
aside his order without.
But they have not challenged, Lordship.
We'll still do it. Is there a bar to do it?
That
Then
is,
the writ court not do it.
no, Lordship,
Then-
but the writ court can do it. But the
Then-
thing is, what is their prayer? Lordship will go beyond their prayer and give something which is not there in
Don't turn it into a, you see,
civil
these are
matter,
matters, huh?
turn into a civil matter.
Yes, yes, these are not matters. You see, somebody has an insurance of his vehicle which is not denied. His vehicle has been stolen away. And you have asked for documents, he's lodged a claim, he's lodged a FIR. You are aware of the claim. You have asked for documents which obviously he didn't have. He is not a scientist, nuclear scientist or someone like that. He's a person who barely is surviving on a vehicle. And you, insurance company, you have all these paraphernalias. So, all right, if the documents he could not produce, why did you ask for these documents?
To
The
settle
original of the registration, should it not be in the car?
No, Lordship, there are certain methods in settling a claim, Lordship. Certain things are needed. Because these officials also, they are also salaried people, Lordship. They cannot go beyond what is there.
That's correct, but you tell us, how do you give the original registration certificate of a vehicle which is stolen and never recovered?
But Lordship, the intimation to the DTO that the vehicle was stolen, that is also required because that intimation and his intimation to the insurance company was also delayed by 12 days. Immediately, he did not inform the insurance.
Then what
company.
would have happened if it was done immediately? Said it was done immediately means within how many days?
Immediately means immediately, like when the FIR is given to the police, Lordship, immediately he should, because after all, the insurance company will
So
be.
what happens if it is not done? The claim becomes redundant.
No, I'm not
Then-
saying that.
then-
I'm not saying that, Lordship, but I'm just saying that in that also he delayed. And when he did not have documents, Lordship, he could have in 2007 itself.
Ms. Majumdar, you see, everything in the legal forum has to have some logic and justification. If there is a murder and delay in lodging an ejahar, that becomes fatal because there is a possibility that by taking time, the victim's family might cook up a story that reduces the dependency or the reliability of the story projected in the FIR. That is why delay would be fatal. What is the, is it a fact that the vehicle was not stolen, but by delaying the lodging of claim is made out a false case? Is that
No,
the ground?
Lordship, the delay, what happens is that if there is a delay, just like in murder case, Lordship, if there is a delay, the vehicle goes out from Assam to Bihar. The vehicle moves out of the state, Lordship. So then the possibility of catching hold it becomes difficult.
How do you catch hold? How do you catch hold? You are not supposed to catch hold. Did the
No,
police-
the police.
Police was informed.
Police, that also, Lordship, I think
Police
police.
was informed.
Let me just check. The police was informed after 4 days, Lordship. On 14/10/2006, the vehicle was stolen, and there on repetition, police
So
station.
that is what he's saying. The vehicle went out. Somebody took it on hire. So reckon from the day when the vehicle went out, it would be 3 days. But how does he know till the vehicle doesn't come back within a reasonable period of time? The owner would not know that it has been stolen because he is using the vehicle for commercial purposes. The vehicle is being taken out on hire. So moment the vehicle is taken, is he supposed to know that it will be stolen and lodged in a?
No, that is not expected of him.
That delay will happen in these matters.
No, Lordship, the vehicle was supposed to come from go from Guwahati to Nagaon. Nagaon is 2.5 hours only distance, Lordship. So from 14/10, when the vehicle did not come back, 15, 16, 17,
These are-
18. But I'm just saying.
These are not bona fide. These are absolutely, you have taken insurance. If there is a doubt about whether there is a valid insurance policy here, or if there is a doubt that the vehicle was being misused for purposes other than for which the insurance was done, these are genuine grounds. If there is some fraud, some foul play, of course, the courts will definitely protect the insurance company. But these are all hyper-technical grounds on which, how can the insurance company hide behind?
Lordship, the three grounds are not all hyper-technical, Lordship, because one ground, that abandonment, Lordship is saying because he did not have the, what I could understand from Lordship, say that since he did not have the documents, so from where he will give. So from Lordship 2007, why did he wait till 2010 to tell that he does not have the documents or whatever, Lordship? Why, does he need 2 years, 7 months, some days?
Which is the clause for abandonment?
Lordship, condition 7. She said she has given the document. I do not have that.
Condition 7.
Annexer L.
Which is condition 7?
Ma'am,
No, apuni kiya document.
Oh,
You have to mark it.
I am not reading on that, your lordship. अपनी नहीं रखा हो, 7 का अपना clause है ना. I'm on this.
This document is
मैं
here.
इधर रखूं, अपनी इंटर पे रखा.
No, that's very rude. Anyway,
I don't know, ma'am, but it's.
No, it's
How will
okay.
it show?
It's okay. This is not given. Lordship, let the registry requisition the document.
Is it there?
Lordship. This is given by her. I do not have a copy.
I
So
don't
I would
know,
like-
it is marked as 7. If only this is what she is saying, then this is the
No,
clause.
I am talking about what was given before the ombudsman, Lordship. This document I have. And
If your lordship will
Alright,
know, I
alright.
shall read that. your
Just a
lordship.
minute. We'll hear you. Just a minute.
let the records from ombudsman come, Lordship. I'll request for that. It can be kept as part heard because it is from here only. Within 2-3 days, it can come, Lordship.
Yes. Just a minute. Let me see what is the judgment. All right, that this judgment is on the facts of the case. If there is a disputed question of fact, then obviously this court will also not entertain. But here, what is the disputed question of fact?
Disputed question of fact that clause 7 lordship, that's why the record will be if there is a clause 7 and then.
Clause 7 of the insurance policy.
Yes, policy, that is marked as annexure L before the ombudsman. lordship.
Annexure
L,
L for London.
yes, lordship. That's what the judgment mentions. lordship.
Okay. All right, then you wait, we'll call for the record, we'll ask the registry to requisition it, and then we'll hear your matter finally. This will be kept part heard.
It's
What else?
Just one
Huh?
thing,
Huh?
just one thing, your lordship.
Yes.
There were 3 grounds on which my claim was repudiated.
Hmm.
The first one, as madam have said, that abandonment of the claim, if only that is the document which I have downloaded from the internet.
Hmm.
Then your lordship, it states that if no suit has been filed within 1 year in any court after the claim has been denied by the company, then claim shall be held abandoned and shall not be recoverable. Now, your lordship, I would like to take you to first order of the ombudsman, whereby
Hmm.
the ombudsman had directed the respondent to
Yes.
settle the matter. Your lordship.
Where is it? Where is it?
Lordship, I'll take you to.
Page number?
Lordship, give me 1 second. I think annexure number 6, your lordship. 21, your lordship, page number 21.
Hmm. Okay.
And your lordship, we had filed this claim before the ombudsman to get settlement of the dispute. Till then, my claim was neither repudiated nor allowed. Then afterwards, they sent a letter to me on 90, this order is of January 3rd of 2000.
So the
12.
claim was not repudiated the day on which you filed the complaint before ombudsman.
Yes, after it was repudiated on 19/1/2012. Sorry, 19th October 2012, and the order is of 13th January 2012. After that, another order was passed by the ombudsman where they have given in favor of the respondent. So till that time, this claim was not repudiated. So this abandonment of claim, this clause will not entertain your lordship.
Okay, okay.
The second one, your lordship. And on the strength of that, your lordship, I have filed few cases to that such delays on that technical grounds when the question of fact is not disputed, that I have been deprived of my property, then those should not be a reasonable ground to deprive me of my insurance claim.
Okay, which are the decisions?
Lordship, this is Jaina Construction Company, your lordship. I flagged and highlighted the portions, your lordship. Jaina Construction Company, it is a decision of 2022, your lordship. It's a Apex Court judgment. Could you find it? Jaina Construction Company versus Oriental Insurance Company, your lordship.
Just a second, just a second.
I'll provide you another copy.
Have patience, have patience. Don't become restless. Hmm. Yes.
Yes, your lordship. This abandonment of claim, the para number 9, your lordship.
Hmm.
In the opinion of the court, the aforesaid ratio of the judgment clinches the issue involved in the case on hand. In the instant case also, the FIR was lodged immediately on the next day of the occurrence of the theft of the vehicle of the complainant. The accused were also arrested and charged. However, the vehicle could not be traced out. Of course, it is true that there was a delay of 5 months on the part of the complainant in informing and lodging its claim before the insurance company. Nonetheless, it is pertinent to note that the insurance company has not repudiated the claim on the ground it was not genuine. It has repudiated only on the ground of delay. When the complainant has lodged the FIR immediately after the theft of the vehicle, and when the police, after investigation, had arrested the accused and also filed challan before the concerned court, and when the claim of the insured was not found to be not genuine, the insurance company could not have repudiated the claim merely on the ground that there was a delay in intimidating the insurance company about the occurrence of the theft. Now, Lordship, there is one more.
Yes.
It is a Lordship Om Prakash versus Reliance General Insurance and another.
Yes.
In this case also, Apex Court stated that insurance company cannot repudiate the claim simply on the ground of delay in filing the claim.
Which is the relevant para?
Lordship, Lordship 11, page number 7, your Lordship. Page number 7, 11th para, your Lordship. It is common knowledge that a person who lost his vehicle may not straightway go to the insurance company to claim compensation. At first, he will make efforts to trace the vehicle. It is true that owner has to intimate the insurer immediately after the theft of the vehicle. However, this condition should not bar settlement of genuine claims, particularly when delay in intimidation or submission of documents is due to unavoidable circumstances. The decision of the insurer to reject the claim has to be based on valid grounds. Rejection of claims on purely technical grounds in a mechanical manner will result in loss of confidence of policyholders in insurance industry.
Okay.
And Lordship has already understood this part, that non-submission of vital documents, even though I had given some case laws, I shall not test that.
All right. We'll requisition the record and then have it next week or after 10 days as a part-heard matter. Ms. Majumdar, we know you are doing your job, but unless there is a lapse which goes into the root of the matter on very flimsy technical grounds, our insurance claim cannot be held to be defeated. That is the prima facie view of the court, which is open to persuasion. So please come prepared on that.
Yes, sir.
And also be aware that your first ground has been rejected by the ombudsman.
No, first ground is staying, that clause annexure L, that is staying. The second ground was
What
about
is-
documents.
Documents, that ground has been rejected.
Second, yes.
Yes, so
was
that has
second.
now attained finality.
Abandonment of the claim as per the policy condition number 7.
But then are these two grounds not interconnected?
uh,
Failure to give documents had led to the inference that
No,
the claim.
he failed to give the documents in 2007. But next he files his application in 2010. So Lordship, there is no connection. If
That's correct.
that
But the
connection is not
claim
there.
has been repudiated, as she says, on 19th of October, 2012, after the ombudsman's proceeding was instituted. So is it not enough indication that the insured was pursuing his claim? How can you say that he has abandoned the claim?
So Lordship, he filed with the insurance company, he has abandoned because he came to this order was ex parte order. This January 13, 2012, and this case he filed in 2012. I'm talking about 2010, Lordship. He gave his application in 2010 itself, and then it was repudiated, Lordship.
All right.
And this application is 2012, and his last order, Lordship, is of 2013.
Your company wants to defeat the claim on some hyper-technical ground, which is not fair. You must.
No, Lordship. Thing is, Lordship, I think Lordship found this is the only case. At least I found this one case and the other one case, Lordship. Otherwise, company is paying. So these things happen when there are certain points. Of course, if the court passes some judgment, we have to honor. That's the
No,
thing.
that's the-
And
what we-
ombudsman also accepted, Lordship, their plea.
No, that's okay. We are not commenting on.
Yes, Lordship.
Everybody has a right to do his or her job. That's
Correct,
another
Lordship.
thing.
Correct, Lordship.
the court is not observing anything against the officials,
Yes, Lordship.
but on a larger platform, the insurance policy is purchased for what? For difficult times like this,
Correct,
bad
Lordship.
times,
Correct, Lordship.
right?
Correct, Lordship.
And these insured persons, they are particularly after the vehicle is lost, they are in distress already. On the other hand, the insurance committee has the company has hundreds of employees, legal department, this department, that department. These poor people don't have it. So unless it is a real case which shows that yes, there was a lot of doubt about the insurance, he never wanted to pursue it. He has given up his claim, and then after some years, he suddenly, just to revive a fake claim, is doing it. Of course, that is the idea of abandonment. Perhaps we don't know.
That is the idea.
That is
of
the idea.
Exactly,
that
Lordship
you
got
can't
it.
harass the company like this.
Yes.
But in a matter which is genuine, just because there has been a delay here and there, is there not a countervailing aspect to this that the company has also asked for documents which obviously were not available? Can it be believed under the motor vehicle rules that the vehicle will ply without the original registration?
Yes, Lordship, it is not necessary
Then
that the
why
vehicles.
did they ask for this document?
No, Lordship, it is not necessary that the vehicle should be applying with the original. 7 days time is given for the DL also and for the, that is the. as per the-
Registration.
Yes, registration.
When was this amended? When was this law amended?
No, not I mean, it is still there, Lordship. It is not a question of.
Registration is not required.
No, 7 days time, the traffic police has to give 7 days time to give the DL, the registration, that has to be a
But then
policy.
every
That is-
car normally has the original.
Maybe a Lordship, I do not keep it. But Lordship, but here Lordship, the abandonment came in because of the 2 years something. Because what is being submitted
No,
in
we'll
12.
ask her next day, we'll ask her.
Yes, yes.
Why this delay has happened.
Yes,
And that has to be shown from the pleadings.
pleadings.
That part is there.
Yes, because the case also they filed, the first case they filed before Ombudsman is in 12. And the second case also after that, repudiation was done immediately after that. And in 13 itself, the order has come against which, after which they have come before Lordship.
So that is correct. If it is found that it is a genuine case of negligence where the insured had set over the matter with no intention, but we'll have to find out what are the grounds.
Yes, Lordship.
So Ms. P. Das, learned counsel, heard Ms. P. Das, learned counsel for the petitioner, also heard Ms. R.D. Majumdar, learned counsel representing the respondents. First, after hearing both the sides, arguments from both the sides at some length, this court, some length, it transpired that perusal of the policy document, more particularly clause 7, policy document bracket annexure L bracket close, produced before the learned ombudsman, more particularly clause 7, would be necessary for determination of the controversy raised in this proceeding. However, the policy document is not available in the record of this case. Ms. Majumdar submits that the original policy document is lying in the records of the ombudsman in connection with complaint number 14-005-043/11-12 pertaining to
No, Lordship, the next one, Annexus 7. Because first one was the direction to the insurance to take up.
okay. Then it will be 14-04
Yes,
-067/11-12 pertaining to insurance policy number 3211-05/7/588/31/2007/1020 lodged by the petitioner as complainant. Full stop. In view, since the ombudsman since the insurance ombudsman is not a party to this proceeding, registry to requisition the records from the office of the ombudsman through a special messenger and list the matter thereafter for further hearing by showing it as a part-heard matter. You please check the numbers in the order so that let us see once the records come, we'll see, we'll balance
Yes,
equities, we'll see. It should not set a wrong precedent for the insurance company in future so that people come up with fake claims. But at the same time, a genuine claim cannot be allowed to be defeated
True,
only
Lord.
on hyper technicalities.
True, Lord.
That will be the parameter in which this matter will be looked into.
Fine.
What will be the claim that we are not going into? If the petitioner succeeds, we'll ask the concerned authority to verify it and settle it. Or we'll dismiss the petition, either of the two. No question of determining any amount. Amount has to be determined as per the policy. All right, yes, there is another matter.
Highly obliged, Lord.
My lord, I have communicated, my lord, because file is old, my lord, record is this need 2 weeks time, seeking 2 weeks time to provide, my lord.
2 weeks
No,
time.
my lord, 2 days, 2 days. They are seeking 2 days time, my lord.
My lord, revalidation is going on long back, lordship may kindly see page.
Oh, but if we don't give them the time, then your order will not be of any
Let it
use.
be allowed.
Let it be next Monday,
Next week.
next Monday.
Yes, yes.
Heard Mr. D.K. Bakshi, Learned Counsel appearing for the writ petitioners. We also heard Mr. A. Bhattacharya, Learned Counsel for respond numbers
1 and 2.
1 and 2. And Mr. M. Chetia, Learned Government Advocate Assam appearing for respond numbers
That's one number, my lord. 3, 4 and 5, my lord.
3, 4 and 5. Stop. Considering the limited nature of grievance expressed in this writ petition, namely refusal to pay the, what is this called? Refusal to extend the
Rehabilitation grant,
Rehabilitation.
the flat affected.
flood relief to the 3 petitioners under the rehabilitation plan drawn up by the district administration, despite the fact that their names were included in the list of beneficiaries. Mr. Chetia was directed to obtain instruction and appraise this court as to the reason for not doing so. Also, the learned government advocate, however, seeks a week's time with a request to list this matter again on Monday, 28/11/20, so as to enable him an opportunity to obtain written instruction and place it before the court. Full stop. Mr. Chetia would also appraise this court as to whether there has been revalidation of the proposal
Yes.
for payment of relief to those beneficiaries who could not be paid at the first instance, and if so, particulars of such revalidation be also placed before the court. Let the matter be looked at accordingly.
And my
Wait.
respond number 4, 5 and 6, my lord. Respond number 3, my lord, is finance, my lord.
Acha, 4, 5 and 6. You wait for 1 week, let
Yes.
us have a clarity on what is happening. A proper order is always a better idea. Otherwise, there will be more confusion. All right. Any other case? Okay.